Hi everyone, how are you? Hope you're all doing well. I know you guys don't like this screen, and I know that my Jules my friend told me, "Hello Jules, if you're listening. I love you." Told me how to not have this on there, and I've got to figure it out. So for right now, we'll just look at my dashboard here. You look at my channel. I mean, here's a picture of me. Here's a picture of my pumpkin patch, but you guys know that's not true because could only successfully grow one pumpkin. But you know. Okay. So I'm gonna have this. So this is Saturday night, and here I am up at 2 a.m. trying to make sense of why nothing is happening in the 7M case. There are many cases that I have seen living in Minnesota that just make me go, what? A couple other letters with that, WTF. And I know that our courts are broken across the United States. I know that right now we are really facing a huge, it's like a pressure cooker in society. We're going through so many different things and changes. So I know that courtrooms across the United States are having a tough time, but the way that we can look at this, we can still say that this 7M case is messed up, and I think it is because of Wright County. And if I have to be drug into in front of a judge and say this, I will say this. I think it's ridiculous. I think it's ridiculous that this case is drug out for so long. I don't feel like this is the way that the justice system should be. I don't feel like this is giving the victim in this case justice. I feel like our courts are supposed to be set up so that there is a system in which when somebody is hurt or if there's a misunderstanding, for the two people to come together and work things out. And when somebody refuses to come to that table and work it out, then the person who has been affected has the right to receive justice. And I'm not seeing that. There are a lot of different cases that I want to talk to you guys about, specifically of what's happening in Minnesota. So while I've taken this hiatus, I've gathered information on the other cases that I want to do, because I want to explain how some of the things that are happening here in the Midwest really need to be looked at. That being said, for my Katie Joy stack here, I just got my paperwork all ready and put all of the things that I think could be relevant and brought up everything from where we're sitting. And it's frustrating because I'm looking at this and I'm going, is this really 2022? Is this really 1 year past that I'm looking at this? Because if I'm going back on this motion and that motion and looking at the protective order and all of this, years are going by and nothing is moving. And why is that okay? The reason why I think it's a problem with Wright County is because if we look at the case of Queen Bee and Blowhorn Betty, that case is moving along very swiftly. Betty is pro se. She's representing herself. And you know what they say about that, you have a fool for a client if you represent yourself. And I don't think any case is more clear than that, looking at it. But, Queen Bee, the community got together and got a great lawyer for Queen Bee. And you just see how that case is just going so much faster. And it has similar themes in that it is YouTube, it is defamation. And other cases that are talked about, we've got how many other YouTube creators going to court, and they're moving, and nothing is happening in this case, and that's not fair for 7M. It's beyond me why this is continuing to happen. It's beyond me that when I think, okay, they could be referring to this, because, okay, if we look at what was stated on October 6, 2023. We have an order from the judge, and what it says here is it'll go into State of Minnesota, County of Wright. 7M Films, Robert Shin, Miranda Derrick, and James Derrick, plaintiffs, versus Catherine Mansky Paulson, aka Katie Joy, and Without a Crystal Ball, which is her LLC, okay, as the defendant. And it's an order written by the judge. And what it says is, the above entitled matter came before Honorable Kari Willis on October 3rd, 2023, for an off-the-record phone conference based upon the representations and agreements of the parties. So they had a phone conference on the 6th of, they had a phone conference on October 3rd. And the way that it states here is, it says, it is hereby ordered that this matter is scheduled for a live hearing on November 15th, 2023 at 10 to address any outstanding discovery disputes between the parties and the rescheduling of dates in the scheduling order entered on July 13th, 2022. Okay, why, like I say, when I just got my stack of Katie Joy stuff, I moved a candy cane. Why did I have to move a candy cane? Because it was Christmas season when this last hearing was. And now I should have a shamrock. It's ridiculous that months are placed between this. Why? Because the holidays? Well, is that fair to somebody who is continually being victimized? No, it's not. Is it fair that what happened on November 15th happened, that nothing happened, that on November 15th they were supposed to address any outstanding discovery disputes between the parties and the rescheduling of the dates that were from the year and a half prior? July 13th, 2022. These dates are ridiculous because now very easily we're going into over 2 years that this is even going to look at scheduling a trial. It's not fair. I don't get it. And I know that people, who have said, well, don't you have the right to a speedy trial? That's in criminal cases. And that's like a good case to bring up is the Koberger case in the Idaho 4. In Brian Koberger's case, where they said, it's probably going to be 2 years before they can go to trial on that because they are going back several generations in his family to explain something relevant. And Brian Koberger waived his right to a speedy trial. Because you can demand as speedy of a trial as you want. You can say, hey, look, I want a trial by I guess if I start talking about Koberger, I'm going to go down a rabbit hole. I digress. I'm sorry, because if I was accused of that heinous of a crime, I would want the best defense, of course, but if I was innocent, I would be not wanting to sit there for 2 years to wait to say I'm innocent. So I think that sometimes when I look at it, I say his not wanting to have a speedy trial, speaks volumes too. But in civil court, it can go forever. I mean, if you've ever been a party to a class action suit, those take years. So the judge next says, the parties shall submit written submissions by October 30th, 2023 at 4:30 p.m. outlining any ongoing discovery disputes between the parties. A letter shall be acceptable. Okay. Wonderful. That was done. It's March 15th. What's happened since? Nothing. That's a problem. This is problematic. Then it says the dates provided in the scheduling order entered on July 13th, 2022 continue to be suspended by agreement of the parties. Okay, so both parties agreed that they weren't ready to go to trial July 13th of 2022. But now we're eclipsing on over a year and a half since that. It's ridiculous. So I'm releasing these videos in real time so that when you are hearing these videos, I should be in the hearing listening to see if they have went forward with the scheduling, and I will be talking about what happened in that hearing, hopefully that night. I still have 20 pages of notes to discuss with you what happened in the last hearing. Now, the truth of the matter is that when you see what happened, it's coming out in one piece of paper and it says, this happened. This didn't, essentially, this didn't happen. And so a lot of people, that's all they want. Okay, here you go. You know that I love to look at the details, and I love to watch human behavior, and I love to watch what isn't said, and I love to read between the lines. And I catch those little idiosyncrasies and the whole vibe. And I think that those of you who get me, and those of you who don't, bye-bye. We're going to do things a little differently this time around. As you can see, I'm not going to necessarily always show what I'm reading from. I don't feel that that was a huge benefit. So people who liked my style from the very beginning found that because I'm not a talented creator visually online, you can listen to my videos as you drive, mop, shower, sleep, whatever you like. I'm just here to kind of tell you a story, and if you like listening, well, then here you go. So I pulled this order. I pulled the protective order to reference. I pulled the basic complaint, and I went and I just checked the register of actions and everything to make sure that everything is still where I see it. I don't see that anything has been added. There's no new memos. There's nothing saying that there's been any other phone conferences that I can see. The one thing is that the judge wrote the order, and that was in January, and there are some very significant things that may be addressed in that. I pulled that there was an order for the motions to compel, and that was, the January 29th, 2024. Now, that's where I think we are going to possibly have some problems, because on January 29th, where katiejoy put all of the focus on saying that it says she's a journalist, whatever. And you'll see this little video where it's also going to go live, where when I heard that, I popped out of hibernation, ran down to the courthouse, and printed off everything and looked, and I was like, no, this is not what it said. And all of these creators were going with this and going with that, and she was going that, and I'm like, no, nothing is saying that. The reason why she wanted to keep that focus on that so desperately is because what was enclosed in the rest of that complaint. And I'm going to talk to you about that. So I pulled that, and then I pulled October 23's paperwork, and I pulled October 2022's, and I pulled, what else I pulled? The motion to compel from July of 2023, and there. So I have that all ready so that if the attorneys are referencing any of this, or the judge is, and they don't have a copy, I can obviously run up and save the day, because, I'm there. And so that's what, I'm just kind of to the point where there are these unfinished tasks. And so looking at this, yes, this should be a scheduling conference. Okay, sure. All right. Let's say that. But what happened when because the judge put out this hearing until now, so what, Tuesday? So when you're hearing this, I should be in court in real time, okay? What had happened was we had a surprise from the judge on, why is this not? Okay. 1/29/2024. is when she put this, and then why is this showing? Okay. I've got it. So basically, it's an order on motions to compel. This is very important, and this is what Katie Joy did not want anybody to hear or put together. She wanted the focus to be on the journalist thing because she knows that's a hot button topic. Okay? So if we do the timing right, Katie basically lost big time. This was a huge win for Amber in what the judge put forth on this date in January. She must have been reviewing some things, and she looked at where we ended, because both sides, and I'll explain what happened in the last hearing, both sides explained where they were, and then it looked like the judge was going to say, okay, I decide this or that. The judge said, all right, well, if anybody has anything else to say, no, all right, well, let's schedule this. She scheduled it out to March. And that's not the way that was supposed to end. That was supposed to end with the judge listening to what was outstanding and say something. She didn't. So instead, she went and she did this on her own time. And huge win for Amber, huge win for 7M in that. The judge said these outstanding motions need to be essentially finished. It was a motion to compel, saying that Katie Joy's side has to answer these things, and in the time limit, it would put it to right where we're going to be at this hearing. So if Katie Joy's side has not done what was supposed to be done here with those motions, and nothing has moved on Tuesday when the two parties come together, the judge is going to say, okay, on January 29th, I put this through and I put this motion to compel. Ms. Moore, how did your client and you come forth? Or it's going to be all done and everything is there, and it's be like, okay, this was there, this is done, we go forward. As we've seen Katie Joy saying that she is not going to settle, she's not ever going to settle, that does not look good to a judge, especially a Wright County judge, because they want you to settle this on your own. Wright County judges do not want to do anything. They want the people to figure it out themselves. So one of two things are going to happen. If these outstanding motions were not finished, then this is going to look really bad for Katie Joy, and they could move for summary judgment, saying that, okay, it doesn't look like they're going to settle anytime soon, so you're in contempt of court, essentially, is the way that I understand it. I don't know if it goes from that to, okay, then fine, we're never going to settle, and we need to schedule the trial. And that's where it's going to be scheduling, and then there's not going to be a problem on these outstanding motions. But I don't know. I've not seen anybody be this unwilling to give during this long of a time frame. Neither side is coming together, because the one side we know will not give. So, the judge says on the order and motions to compel. Once again, we've got 7M as plaintiffs, got Catherine Mansky as the defendants. The judge states, the above entitled matter came before the Honorable Kari Willis, Judge of District Court, for hearing on November 15, 2023, on the parties' motion to compel. Amber Stavig appeared on behalf of the plaintiffs. Jennifer Moore appeared on behalf of the defendants. The court held a phone conference with the parties prior to the hearing and requested they meet and confer to narrow the pending discovery disputes. The parties submitted correspondence to the court on October 30th, 2023, regarding the outstanding discovery disputes. The parties presented oral argument to the court on November 15th, 2023, and the court took matter under advisement as of that date. Based on the files, records, and pleadings herein, the court makes the following findings of fact. Number 1, Plaintiff 7M Incorporated. Plaintiff 7M Films Incorporated is a talent management company, and Robert Shin is its CEO and sole owner. Plaintiffs Miranda and James Derrick are husband and wife associates of Mr. Shin. Plaintiffs' business is in the field of social media communications and marketing. Additionally, they broker deals between performers, particularly dancers, and commercial venues. Number 2, under findings of fact. Ms. Paulson runs several social media accounts with substantial reach, numbering in the tens of thousands or hundreds of thousands of followers, particularly on Instagram and YouTube. Plaintiffs alleges 9 causes of action against defendants. The first 2 counts for defamation and defamation per se underlie the remaining counts. In summary, plaintiffs allege that Ms. Paulson, via her Instagram page and other social media platforms, defamed plaintiffs by posting false statements about 7M and associated individuals. Plaintiffs maintain that Ms. Paulson's social media posts claim that plaintiffs are involved with Shekinah Church, which plaintiffs argue that Ms. Paulson characterizes as a cult. Plaintiffs further claim that Ms. Paulson has acquired and published court documents subject to a protective order involving plaintiffs, and that Ms. Paulson has stated that plaintiffs engage in criminal conduct, including human trafficking, waterboarding, and kidnapping. Plaintiffs' other claims are rooted in the same allegedly defamatory conduct by defendants, but are pled as tortious interference with contracts, intentional interference with prospective advantage, deceptive trade practice, negligence, and intentional infliction of emotional distress. Okay? Side note, I'm going to put an asterisk here. Do you recall when Katie Joy was just talking about another creator who did a video about her? And so Katie was saying that she could charge that other creator with tortious interference and prospective advantage and whatnot. Katie Joy is incorrectly trying to pervert these things that she is seeing in what she is accused of, that she thinks she can now put against others for making videos about her. It's bizarre. Side note, done. Back to the script. Conclusions of law. Number 4. Rule 26.02 of the Minnesota Rules of Civil Procedure governs the scope and limits of a discovery. It states in pertinent part that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of that case, considering the importance of the issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, the parties' resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. And that's in the Minnesota Rules of Civil Procedure 26.02b. And then we go over here to 5. The court may limit discovery that is unreasonably cumulative or duplicative, obtainable from another more convenient source, or unduly burdensome. And that cites in regard to Milk Indirect Purchaser and the antitrust litigation on 588, blah, 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 citing Minnesota Rules of Civil Procedure 2603. Okay, then we come over here and we say that Plaintiffs' interrogatories 11, 12, 14, 15, 16, 17, 18, 19, 21, 34, 40, and 41, and requests for production of 11, 12, 13, 15, and 16. Plaintiffs have demonstrated that the requested information relates to the claims and damages asserted in this lawsuit. By her own admission, Ms. Paulson has a massive social media presence and has discussed plaintiffs on several platforms. The sources and veracity of that information is relevant to many of the claims asserted by plaintiffs. The information is not overbroad, as it is limited to statements made and information obtained about plaintiffs within a specific time period. Okay, now, we're going to go to the next part. The next part should already have, there should be another video either coming out right now or very shortly after, where I speak specifically to this paragraph here that Katie Joy wanted you to look at and not look at the other parts of, because the next part here states that defendants claim that plaintiffs are not entitled to much of the information sought by plaintiffs because of journalistic privilege and or because of the information qualifies as journalistic notes. Okay. The issue of whether or not Ms. Paulson is a journalist has not been presented to or decided by this court. To the extent that the defendants maintain that the sources of some of this information are confidential informants or qualify as journalistic notes, they can provide that information to plaintiffs pursuant to a privilege log in accordance with Minnesota Rules of Civil Procedure. Okay. This is very problematic. This is a side note of me. This is very, very relevant and problematic because in the hearing that I've not given all of the details for, this is why. Because her attorney stepped in a big pile of shit because her attorney stated that her client is a one and done, does not keep notes of any kind, that there are no rough drafts, that her client is indeed a product of this generation where they are not like me, for example, or Jennifer Moore, where we did rough drafts and graphed things out and did outlines and whatnot. Jennifer Moore stated that her client does not have any notes whatsoever. So I'm very, very concerned about how that piece fits in here. When this came out, I saw this as a huge problem because of what has been said. And I don't know how they can unring that bell. I think it's problematic, is that either there are the notes, either you are this journalist and you have these notes, or you don't. And as the attorney has stated that her client does not, that there are no notes, then how can the judge then say that, okay, well, this can be settled by this? Because the judge already heard it be said that there are no notes. So then how can the judge put this out here as a possible solution? These are the things that I'm very, very concerned with. Is that I don't know. I mean, I keep notes of everything I do on my channel so that in the event that I am called in front of the judge, whatever, and that's why I don't necessarily do panels, because if a panel starts a discussion and then I'm a party to that discussion and that discussion goes in different ways, which may be things that I'm not necessarily comfortable in saying, I am a party to that, what is being said, by agreeing. And so I'm very, very careful of my words and my scope of what I say, so that if I do have to answer to them, I can say this is how I derived this statement or this concept. So I don't know, this one really has me thinking. So I digress. Back to the script. Plaintiff's request for production 17 and 18. The court also finds this information to be discoverable. The issue of whether defendants were compensated, how much they were compensated, and by whom they were compensated from January 2020 to present is relevant to defendants' motives in discussing plaintiffs on social media platforms, including the depth, length, and substance with which plaintiffs were the focus of Ms. Paulson's discussions. Okay, side note, when I tell you more about what happened in that last hearing, I will go through that in depth as well. Now we have here plaintiff's request for production 19, 20, 21, 23, and 24. Similarly, these requests are discoverable as they relate to defendants' motives in potentially gaining financially from their discussions regarding plaintiffs. Defendants offer no legal support for their claim that the production companies would be required to make an independent argument regarding the disclosure of any contracts they entered into with defendants, and the court does not find that argument persuasive. Okay, so the judge is making a ruling on the argument that they had. Boo! Come here, Boo Boo. Come here. Sorry, Boo Boo just discovered his tail again, and it's very dramatic when it happens. Boo Boo. Oh, I'm sorry. I staticked you. I'm sorry. Boo Boo. Okay, so defendants' interrogatories 6 and 7. These interrogatories written are overbroad. Defendants contend that they are seeking evidence of statements against interest. However, the interrogatories are not limited to statements against interest, nor are they related to a specific time period. Furthermore, they do not identify the general substance of the statements defendants are seeking. Okay. Defendants' interrogatory. This interrogatory is also overbroad as written, as it is unanswerable in its current form. Defendants stated they would limit the communications to communications about the lawsuit or claims in this litigation, but the interrogatory seeks information prior to the commencement of this litigation. Defendants' limitation does not render the interrogatory answerable. Okay. And this is where, when I pulled the things, I pulled the original complaint, because I think I'm going to have to go back to the complaint and the interrogatories to find out what they're talking about in some of these things that are unanswered. And then, of course, we don't have Shin's side, because that's protected by that's covered under the protective order. Now, the protective order has different levels in which information is out. That being said, then we have defendants' interrogatories 10 and 11. And it says, these interrogatories request information relevant to the claims or defenses in the lawsuit. Okay, so that's relevant. And then it says defendants' interrogatory 12. This interrogatory is overbroad and not likely to lead to discoverable information. Okay. Then we go to defendants' interrogatories 14, 15, 16, 17, and 19. And it says these interrogatories request information relevant to the claims or defenses in the lawsuit. Okay, so that's another thing that has to be done. And then it has defendants' request for production 6 and 7. And it states this request is relevant to the claims or defenses in this lawsuit, but should be limited to the time period from January 2020 to the present. Okay. And then we have defendants' request for production 8 and 16. These requests are overbroad as written, and defendants have not demonstrated they are relevant to the claims or defenses in this lawsuit. Okay. So that's a loss. And then it says defendants' request for production 9, 14, and 20. These requests are relevant to the claims or defenses in this lawsuit. Okay, so we've got some wins and we've got some loses, okay? Some wins and losses, not loses. So then the order states that the plaintiff's motion to compel is granted with respect to all disputed interrogatories and requests for production. That's where this is a huge win for Amber. That's why Katie Joy wanted this to be, oh yeah, the judge said I'm a journalist. No, the judge said that the plaintiff's motion to compel is granted. In bold letters, granted. And then we have defendants' motion to compel is granted in bold with respect to interrogatories 10, 11, 14, 15, 16, 17, and 19, and requests for production 9, 14, and 20 are granted in part with respect to requests for production 6 and 7. The remainder of defendants' motion to compel is denied. Okay. The parties shall continue to abide by the terms of the protective order entered on February 7th, 2023. Okay, we know about the protective order. And then it says this matter remains set for a live scheduling conference on March 19th, 2024 at 9 a.m. And so I will be there with bells on. And then all that was in there, then it was filed that this was there, that an order on motions to compel was placed that on January 29th, 2024. So that was served to Katie's counsel. So they should have been busy making sure that all of these things are answered, and they'll have that to bring to the judge, and everything will be wonderful, and each party has been moving together and trying to find a solution. But this is Katie Joy we're talking about, and she said, when hell freezes over, will I settle or do anything? I don't have to do anything. So at that point, then we will see that either her lawyers talk some sense into her and she moved towards a solution, or not. And I will do my best to do a recording talking about what happened that night, and then I will get you caught back up to everything that happened in the 3-hour hearing back in November, because it's relevant to what's happening now. Thank you for understanding that I had to take a break from everything, and I hope that things will be a lot more straightforward moving on. Thank you for supporting me and listening and understanding that I don't have a bunch of visuals for you. And I hope that I was there for you while you did your dishes or showered or gardened or whatever you did. Let me know what you were doing in the comments. Let me know what you were doing while you were listening to me. I appreciate things like that. Thanks for bringing me along to wherever you are. And I will be I'll be reporting again soon. Thanks for listening. Have a great day. Bye-bye.